It's a great pleasure to have him in Hong Kong, Professor Galanis.
Wonderful. Down a little bit. I want to thank the Faculty of Law and especially Dean Hualing Fu and Professor Lucina Ho for inviting me as an academic visitor. The Gospel of Matthew tells us that by their fruits ye shall know them. And it was by reading the scholarship of so many superb members of the faculty in my capacity as a member of the law panel for the 2020 Hong Kong Research Assessment Exercise that I came to know and admire the depth and breadth of the academic talent here. So it's a great honor and delight for me that my first post-pandemic visit to Hong Kong is to the Faculty of Law at HKU. My lecture tonight is titled The Dark Side of Codifying U.S. Trust Law. For most of Anglo-American history, trust law was case law. The Anglo-American law of trust was born and molded in the English Court of Chancery, and then on U.S. shores reshaped by the courts of the U.S. states. Trust law in this respect stood in sharp contrast to the law of intestacy and wills, where for centuries prominent statutes also governed. Examples of such statutes are the Statute of Distribution and the Statute of Frauds, both from the reign of Charles II, and the Wills Act from the first year of the reign of Victoria. In the US, prestigious organizations drafted comprehensive codes of probate law, but not of trust law. The Model Probate Code was published in 1946, thanks to a joint effort by the American Bar Association's section of real property, probate, and trust law and the University of Michigan Law School. The Uniform Probate Code was published in 1969 by the Uniform Law Commission. But the feature of trust law as largely decisional law remained true in the US even when I began teaching the law of trust and succession in 1997. The US law of trust primarily was to be found in the decisions of state courts and in respected secondary sources, digesting and refining the rules from those decisions, such as the American Law Institute's restatements of the law of trusts and the multi-volume treatises on trust law, originally authored by Austin Wakeman Scott of the Harvard Law School or George Gleason Bogert of the University of Chicago Law School. To be sure, there were some statutes affecting trust law. For example, the Uniform Principal and Income Act, which was originally published in 1931, the Uniform Trustees Powers Act, originally published in 1964, and the Uniform Prudent Investor Act of 1994. Additionally, the states of California, Georgia, Indiana, Louisiana, Oklahoma, Texas, and Washington had codified their state's trust law. But in most US states, trust law primarily was case law. US trust law no longer is primarily case law. In 2000, the Uniform Law Commission published the Uniform Trust Code, or as I'll call it, the UTC. So far, 35 states and the District of Columbia have enacted enough of the UTC to be counted by the Uniform Law Commission as enacting jurisdictions. The UTC is one of the Uniform Law Commission's successes. By contrast, the Uniform Probate Code has only 18 enacting jurisdictions. Emboldened by the success of the UTC, the Uniform Law Commission subsequently published additional statutes in the field of trust law. These include the Uniform Trust Accounting Act of 2015 and the Uniform Directed Trust Act of 2017. The Uniform Law Commission also published statutes in fields of law allied to trusts. For example, the Uniform Powers of Appointment Act of 2013 and an updated Act on Principal and Income, now titled the Uniform Fiduciary Income and Principal Act in 2018. So US trust law is now heavily statutory. In a law review article published in 2007, when the UTC was much newer and the post-UTC Uniform Acts in or allied to trust law were not yet envisioned, Professor John Langbein offered an explanation for this shift in the law of trusts from case law to statute law. He pointed to multiple factors, including the transformation of the trust's core function from the passive transmission of land to the active management of financial assets, the rise of a national trust management industry seeking modernizing legislation, the Uniform Law Commission's desire to provide such legislation, and the availability of statutory type language on many topics related to trust law in the restatements. My lecture examines not the causes, but some of the consequences of this shift in the law of trust from case law to statute law. For convenience, I call this shift codification because we have no word in English for statutification. The publication of the UTC was codification in the standard sense, meaning the systematization of a body of law into a comprehensive code. The publication of the other trust statutes is not codification in that standard sense. Still, for convenience, I refer to all of these examples of case law turned into statute law as codification. In many respects, the publication of uniform statutes in or allied to trust law has achieved the goals of the Uniform Law Commission. The harmonization, modernization, and codification of the law in so many U.S. states facilitates multi-jurisdictional trust activity and provides each enacting jurisdiction with a comprehensive law of trusts, whereas previously only the questions of trust law litigated in the state would have produced clear answers in the state's decisional law. Nonetheless, the publication of these statutes sometimes has led to the frustration of the goals of the Uniform Law Commission. In other words, there's been a dark side to the codification. The dark side of the codification arises between the publication of the statute and its enactment by the state legislature. After the Uniform Law Commission publishes a uniform statute, the statute is considered for enactment by the various states. With respect to a uniform statute in the field of trust and succession, the consideration typically begins in the section of the State Bar Association, or in a major city, the committee of the City Bar Association that's concerned with estate planning. In my home state of Illinois, for example, the State Bar Association has a section on trusts and estates. The Chicago Bar Association has a trust law committee. But putting terminology aside, the Bar Association section or committee plays a key role in determining whether and in what form a uniform statute in the field of trust or succession will become law. A bill in the area of trust or succession that's supported by the Bar Association is likely to be approved by the legislature and signed by the governor. A uniform statute in trust or succession, or a provision within the statute that is opposed by the Bar Association, is unlikely to see the light of day. Also influential are national or regional associations of corporate fiduciaries and bankers. Examples include the American Bankers Association and the Corporate Fiduciaries Association of Illinois. Uniform statutes in trust or succession rarely are enacted verbatim. More commonly, the statute is modified to a lesser or greater degree by the enacting state. This typically occurs during the process of study by the bar and other associations prior to the bill's introduction in the legislature. From the perspective of the Uniform Law Commission, some of the modifications have been innocuous. For example, adjusting uniform provisions to conform to the particular state's law or practice. But some of the modifications have been harmful to the outcomes the Uniform Law Commission sought to achieve. I rarely use sports metaphors, but here one seems apt. By codifying what had previously been case law, the Uniform Law Commission scored own goals. Let me give 3 examples where the process of codification itself opened the door to outcomes opposite to what the Uniform Law Commission sought to achieve. These examples concern, first, general powers of appointment, creditors' rights, and the Uniform Powers of Appointment Act. Second, the movement to allow perpetual or near perpetual trusts, and the uniform statutory rule against perpetuities. And third, the trustee's duty to provide information to the trust beneficiaries and the Uniform Trust Code. So let me begin with general powers of appointment, creditors' rights, and the Uniform Powers of Appointment Act. A power of appointment is defined as authority other than as an incident of beneficial ownership of property to designate recipients of beneficial interests in property. Essentially, it's a power to choose who will receive property that you do not own. Powers of appointment add flexibility to the trust arrangement. They enable the power holder to make decisions about the ownership interests in the trust property, thereby enabling later facts and circumstances to be taken into account, especially facts and circumstances arising after the grantor's death. This helps make trust flexible and responsive to changing family needs. This flexibility is a tremendous asset in property planning. The Harvard professor W. Barton Leach described the power of appointment as the most efficient dispositive device that the ingenuity of Anglo-American lawyers has ever worked out. Powers of appointment in American law are either general or non-general. A power of appointment is general if the power can benefit the person who holds the power. In the technical definition, a power is general to the extent that the power is exercisable in favor of the power holder, the power holder's estate, the creditors of the power holder, or the creditors of the power holder's estate. Essentially, a general power of appointment is akin to ownership. The power holder can exercise the power for his or her own benefit. For this reason, the Restatement Third of Property states that property subject to a general power of appointment is subject to the claims of the power holder's creditors. More specifically, the Third Restatement's rules on creditors' rights in appointed property are on your handout, and they are as follows. First, to the extent that the property owned by the power holder is insufficient to satisfy the claims of the power holder's creditors, property subject to a presently exercisable general power of appointment created by someone other than the power holder is subject to those claims to the same extent that it would be subject to those claims if the property were owned by the power holder. And upon the death of the power holder, to the extent that the power holder's estate is insufficient to satisfy the claims of creditors of the power holder's estate, property subject to a general power of appointment created by someone other than the power holder and exercisable by the power holder's will is subject to those claims and expenses to the same extent that it would be subject to those claims and expenses if the property had been owned by the power holder. Consistent with the Third Restatement, Section 502A of the Uniform Powers of Appointment Act, which is on your handout, provides appointed property subject to a general power of appointment created by a person other than the power holder is subject to a claim of a creditor of the power holder to the extent the power holder's property is insufficient if the property is presently exercisable, and the power holder's estate to the extent the estate is insufficient, subject to the right of a decedent to direct the source from which liabilities are paid. These provisions were approved by unanimous votes of the membership of the American Law Institute and the state delegations of commissioners of the Uniform Law Commission. The provisions also harmonize with U.S. federal transfer tax law, which since 1942 has treated the holder of a general power of appointment as the equivalent of the owner of the appointed property. Section 2041 of the Internal Revenue Code provides, and is on your handout, that the value of the gross estate shall include the value of all property to the extent of any property with respect to which the decedent has at the time of his death a general power of appointment created after October 21, 1942. With respect to powers created on or before that date, October 21, 1942, property subject to a general power was included in the power holder's gross estate for federal estate tax purposes only to the extent the power was exercised. This requirement of exercise as a prerequisite to creditor satisfaction also is reflected in some state case law predating the Third Restatement. Well, in recent years, we've seen a substantial increase in the exemption from U.S. federal estate and generation skipping transfer taxes. In 2024, the exemption is, wait for it, 13.61 million US dollars per person. The large exemption has made transfer tax planning irrelevant for many clients. Instead, the clients are concerned with income tax planning. For purposes of income taxation, property over which the decedent held a general power of appointment receives a step up in basis in the hands of the recipient. This is a great benefit with respect to property that's appreciating in value. It means that the recipient of the property pays less in income taxes if the property is later sold because there's less capital gain. Capital gain is the positive difference between the sale price and the adjusted basis. If the basis is stepped up, then the capital gain on the appreciated asset is reduced. Consider an example that you have on your handout. Suppose that our grantor P created a revocable trust while alive, then died in 2012. On P's death, the assets in P's trust are held for the benefit of P's child A for A's life, with the remainder to pass at A's death to A's surviving children. Suppose that at P's death, the trust assets consisted of $5 million of marketable securities. The estate and generation skipping transfer tax exemption in 2012 was over $5 million, $5.12 million. So P's estate paid no estate tax on the trust assets. P's executor allocated $5 million of P's generation skipping transfer tax exemption to the trust, causing what the tax code calls a zero inclusion ratio, and that will become important at A's death. So let's fast forward to A's death. 9 years later, in 2021, he's survived by two children, X and Y. The trust assets aren't subject to estate tax at A's death because A had only a lifetime interest in the trust, and they're not subject to generation skipping tax at A's death because of that zero inclusion ratio. So suppose that at A's death, the trust assets had appreciated in value to $11 million. What that means is X and Y receive $11 million worth of securities, or $5.5 million each. But the basis is the value at P's death of $5 million, or $2.5 million each. What this means is that if X needs or decides to sell X's half of the securities, X is going to have to pay income tax on the capital gain of $3 million. That's the market value of $5.5 million minus the basis of $2.5 million. But now let's change the facts. Suppose instead that the terms of the trust also granted or enabled the trustee or trust director to grant a general power of appointment to A. This changes the tax consequences. The power of appointment triggers the inclusion of the trust assets in A's taxable estate. But that's no problem because the large exemption from estate and generation skipping transfer taxes, $11.7 million in 2021, means that no transfer taxes are incurred. The recipients, X and Y, receive the assets with a stepped up basis, the basis as of A's death of $11 million, or $5.5 million each. So now, if X needs or decides to sell X's half of the securities, zero capital gain is incurred. The sale price is the same as the stepped up basis, so the difference between them is zero. The availability of this strategy, using a general power of appointment to trigger a step up in basis, has prompted estate planning lawyers to write documents liberally granting general powers of appointment. As one lawyer confessed to me privately, general powers are now sprinkled like candy. The transfer tax consequences to the power holder are irrelevant because of the large transfer tax exemption. What is sought is the income tax step up for the recipients. Still, there's a problem. From the perspective of property law, a power holder with a general power of appointment has a power that's akin to ownership. To avoid the consequences of ownership, such as creditor access, bar and other associations have lobbied to change the rule on creditors' rights in 9 of the 12 state enactments of the Uniform Powers of Appointment Act. In 4 of these 9 states, the rule that the legislature adopted is essentially the same as the pre-1942 rule under the federal transfer tax law, namely that property subject to a general power is reachable by creditors only if the power is exercised. But in the other 5 out of 9 states, the new rule goes even farther. Property subject to a general power is exempt from creditor claims, even if the power is exercised. Under either category of the new statutory language, the lawyers have their candy and eat it too. The general power qualifies for the step up in basis on the rationale that the power is akin to ownership, yet the appointed property remains outside the reach of the power holder's creditors. And in 5 states, even an exercised general power affords no basis for creditor satisfaction. This latter result would have been hard to imagine as a matter of decisional law. Instead, the door to this outcome was opened by the process of codifying the law of powers of appointment in the Uniform Powers of Appointment Act. So let me turn to my second example, the movement to allow perpetual or near perpetual trusts and the Uniform Statutory Rule against perpetuities. The rule against perpetuities is a longstanding rule of Anglo-American common law. It prohibits the remote vesting of contingent future interests in property. The classic formulation in American law was stated by Professor John Chipman Gray of the Harvard Law School, and you have it on the handout. No contingent future interest is good unless it must vest, if at all, not later than 21 years after some life in being at the creation of the interest. Under this rule, a contingent future interest in property is invalid from the beginning if there's a possibility that the interest might not vest in time. The second restatement adopted the same perpetuity period, but added a wait and see component, validating a contingent future interest if it actually did vest within the perpetuity period. Now, the wording of the rule against perpetuities is complex, but the major consequence of the rule can be directly stated. In the modern era, the principal effect of the rule is to limit the duration of trusts. But recent decades have seen a movement in the United States to abolish the rule against perpetuities or to make it optional, or greatly to extend the perpetuity period. The standard historical account of this movement places the blame on federal tax law. In 1986, the federal government enacted the current regime of the generation skipping transfer tax. I'll just call it the GST tax. That tax imposes a tax on trusts that persists through more than one generation. But the tax contains a large exemption, and for trusts valued below the exemption amount, Congress made the mistake of relying on state perpetuity law to control trust duration. That put the duration of tax-exempt trusts in the hands of the states, whose interest is more in generating trust business than protecting federal tax revenue. Hence was born the movement to allow perpetual or near perpetual trusts. Or at least that's the standard version. I think this historical account is incomplete. The year 1986 also saw the publication of the Uniform Statutory Rule against perpetuities. The Uniform Statutory Rule reformulated and greatly simplified the common law rule against perpetuities. For dispositions that fail the common law rule, the Uniform Statutory Rule provides a wait and see period of 90 years. And the aim of choosing 90 years rather than some other number was to fix a period of time that approximates the average period of time that traditionally would be allowed by the wait and see doctrine as it had developed in the case law. But if the rule against perpetuities could be restated by statute as a 90-year limit, what was special about 90 years? Why not 150 years, as now provided in the state of Washington, or 300 years, as in Texas, or 360 years, as in Alabama, Georgia, Michigan, Mississippi, and Tennessee, or 365 years, as now in Nevada, or 500 years, as now in Arizona, or 800 years, as in Connecticut, or 1,000 years, as now in Colorado, Florida, Utah, and Wyoming, or forever, as in the more than 20 US jurisdictions that now allow perpetual trusts by statute. The transformation of the rule against perpetuities from its lives in being formulation at common law to a statutory period of 90 years helped to open the door to further statutory change of perpetuities law in the form of the perpetual or near perpetual trust movement. It was not intended by the Uniform Law Commission, but it was a consequence of the uniform statutory rule, and especially of the rule's codification of the perpetuity period as a flat period of years. Let me now turn to my third and final example, the trustee's duty to furnish information to beneficiaries and the Uniform Trust Code. The US law of trust has long held that the creator of a trust, the settlor, may not eliminate the trustee's duty to furnish at least some information about an irrevocable trust to at least some of the trust beneficiaries. The reason for a mandatory duty to furnish information is straightforward. The trustee has a mandatory duty to furnish at least some information about an irrevocable trust to at least some of the trust beneficiaries, because only the beneficiaries have both the legal authority and the economic incentive to monitor and enforce the trustee's performance. Consistent with the rule approved by the membership of the American Law Institute and articulated in the restatements, the official text of the Uniform Trust Code provides that a settlor may not eliminate the trustee's duty to furnish at least some information about an irrevocable trust to at least some of the trust beneficiaries. This is Uniform Trust Code Section 813A, which is on your handout. That provision is made mandatory by Section 105 of the UTC, which distinguishes the mandatory rules of trust law from the default rules of trust law that can be modified or eliminated by the terms of the trust. As you see on your handout, UTC Section 105 includes the duty to inform at least some of the beneficiaries, qualified beneficiaries, of certain information. But of the 36 jurisdictions in the US enacting all or most of the Uniform Trust Code, 17 have deleted the duty to furnish information from the Trust Code's list of mandatory rules, and some other jurisdictions have weakened the duty. The effect is that in these jurisdictions, the law has enhanced the power of the settlor to create a silent or semi-silent trust in which the beneficiary's rights to information are eliminated or curtailed. Those changes in the law would have been difficult to achieve by judicial decision-making, but they were achieved by the stroke of a pen by the process of codification. So let's step back from the examples. What can we say as a general matter? Law reform in the US in the field of trust or succession often occurs through the efforts of the American Law Institute or the Uniform Law Commission. The American Law Institute publishes the restatements, the Uniform Law Commission publishes uniform statutes. Those publications have different primary audiences. The restatements are designed to influence courts. Uniform statutes are designed to be enacted by state legislatures. If a restatement articulates a rule that's different from the rule in the state's current case law, a court in that state typically is faced with three options. One, maintain the state's rule currently in force. Two, adopt the restatement rule. Or three, adopt a different rule from another state. It would be rare, possible but rare, for a state court to announce a rule not in any of the three categories, but entirely new. A state legislature or a state bar association or other interest group considering the adoption of a statute is not so constrained. The insertion or deletion of a few words in a statute can create an entirely new rule with the stroke of a pen. Consider my first example, the rights of a creditor of a holder of a general power of appointment. One rule, articulated by the first and second restatements, said that the creditor may reach the appointed property if the power was exercised. A different rule, articulated by the third restatement and consistent with the federal transfer tax law, says the creditor may reach the appointed property even if the power is not exercised, because a general power is akin to ownership. A court facing the question as a matter of first impression almost certainly would decide between the two rules. But with the stroke of a pen, interest groups in some states modified the Uniform Powers of Appointment Act to create an entirely new rule. The creditor may not reach the appointed property even if the general power is exercised. The point I'm making here is that law reform by legislation is fundamentally different by law reform by judicial decision in at least two respects that are salient for the law of trust. First, the range of choices available to a legislature typically is broader than the range of choices available to a common law court. Second, the process by which a draft statute, such as a uniform act, becomes enacted is more open to capture by a state bar association or other interest group than the process by which a restatement rule becomes a part of a state's decisional law. These differences between law reform by legislation and law reform by judicial decision also appear in the other two examples, the rule against perpetuities and the duty to furnish information. In a state with the common law rule against perpetuities, it's hard to imagine a court declaring a new rule authorizing a future interest to remain contingent perpetually. Similarly, in a state with precedent articulating the trustee's duty to furnish at least some information about the trust to at least some of the trust beneficiaries, it's hard to imagine a court declaring a new rule authorizing an entirely silent trust. But these results are easy to achieve by legislation. Law reform accomplished with the stroke of a legislative pen has its benefits, but also its pitfalls. The three examples illustrate how statutes published by the Uniform Law Commission were used to achieve outcomes opposite to those the Uniform Law Commission intended. So, could the Uniform Law Commission have done something different to avoid the problem? The answer is yes. Let's explore this. Let's consider the uniform statutes in the same order as before and see what the Uniform Law Commission could have done. Let's begin with the Uniform Powers of Appointment Act. The Uniform Powers of Appointment Act consists of 6 articles. Only Article 5 on creditor rights has led to outcomes that the Uniform Law Commission did not want. This could have and should have been foreseen. The Uniform Law Commission could have omitted the publication of Articles 1, 2, 3, 4, and 6 would have achieved most of the Commission's goals in codifying the law of powers of appointment. The rules on creditors' rights could have been left to the case law. As a matter of case law, a state court would have been unlikely to announce the entirely new rule now in force by statute in 5 states, namely that the creditors of a holder of a general power cannot reach the appointed property even if the power is exercised. Now let's turn to the Uniform Statutory Rule against perpetuities. What could have been done differently? The fact is that well-drafted trust instruments don't violate the rule against perpetuities. It's not because lawyers have mastered the intricacies of the rule. Rather, it's because well-drafted trust instruments contain a perpetuity saving clause. And you have an example on the handout. The clause says, the trust hereby created shall terminate in any event not later than 21 years after the death of the last survivor of my descendants who are in being at the time this instrument becomes effective. And unless sooner terminated by the terms hereof, the trustee shall, at the termination of such period, make distribution to the persons then entitled to the income of this trust, and in the same shares and proportions as they are so entitled. This perpetuity saving clause has 4 effects. First, the clause ensures that the contingent future interests in the trust do not violate the rule against perpetuities by guaranteeing that the trust will not remain contingent beyond the life in being plus 21 years. Second, the clause transforms the application of the rule to this trust into a wait-and-see regime. The clause is a mere backstop that will be triggered only if the other dispositive provisions of the trust do not terminate the trust in time. Third, the period of time established by the saving clause probably overinsures because experience with trusts in jurisdictions with the rule against perpetuities shows that most trusts terminate on their own before the end of the perpetuity period would be reached. In other words, the saving clause in most instances helps to ensure that the settlor's dispositive plan can be achieved. And fourth, the clause provides distributional instructions if the settlor's dispositive plan truly would violate the perpetuity rule. The uniform statutory rule against perpetuities did not need to replace the lives in being formulation with a fixed period of years. Instead, the uniform statutory rule could have adopted a more modest reform. It could have inserted by statute a properly drafted perpetuity saving clause into trust instruments not having it. This would cure the perpetuity violation and in most cases would allow the trust to continue until it terminated naturally. Finally, let's turn to the Uniform Trust Code and the duty to inform. The Uniform Trust Code did not have to be so explicit that the duty to inform is a mandatory rule. Broadcasting the duty to furnish information as a mandatory rule was the equivalent of brandishing a red cape in a bullring. Indeed, it was a red cape that soon led to the white flag of surrender. 4 years after the UTC was published, the Uniform Law Commission was forced to admit that the mandatory duty to furnish information, and here I quote, generated more discussion in jurisdictions considering enactment of the UTC than have any other provisions of the code. The commission surrendered by placing the relevant provisions in brackets to indicate that future jurisdictions considering the Uniform Trust Code did not have to include the duty to inform in the list of mandatory rules. But in drafting the Uniform Trust Code, the Uniform Law Commission should have omitted the list of mandatory rules entirely. This would have allowed the case law and the restatements to flesh out the contours of fiduciary duty, including the duty to inform, and the limits on the settlor's ability to alter or waive those fiduciary rules. So let me conclude. The process of codification itself opened the door to outcomes opposite to what the Uniform Law Commission sought to achieve. This danger is not limited to uniform statutes. The danger is present whenever statutes are considered for enactment on a topic previously the domain of the common law. In this lecture, I've offered examples from uniform statutes simply because the Uniform Law Commission is the largest producer in the United States of statutes on trust law. The Commission and other advocates for converting the common law of trusts into statute law should be mindful of the dangers of codification. Codification has its benefits, but it also has a dark side. Thank you.